IVM.
Hey, it's been another great week on IVM. If you aren't following us on social media, please do. We're IVM Podcast on Facebook, Twitter, and Instagram. On Cyrus Says this week, we have Satyanshu Singh, filmmaker, writer, and head of content development for AIB First Draft. His journey from doctor to writer is a fascinating one. On The Scene and the Unseen, Amit is joined by Pranay Kotastane and Hamsini to decode Pakistan's experiences with democracy. On Keeping It Queer this week, Naveen speaks to Parmesh Sahani, author and head of the Godrej India Culture Lab. Hustle Science marks the season finale with fitness YouTuber Abhinav Mahajan. And on Geek Fruit, Tejas and Jishnu give you the greatest hits from this year's San Diego Comic-Con. It's time for you to catch the third story from Croc Tales with Anand Sivakumaran. This one is called Freddy Ki Fiat Ho Gayi Flat. And now, onto your shows.
Did Pakistan get a privacy law before India? And what's a data protection law, and how is this different from a privacy law? And now that the Indian Supreme Court has declared that we all have a fundamental right to privacy, can we all go home happy? All this and more in this 2-episode special of the Pragati podcast. Welcome to the Pragati podcast, a weekly show on economics, public policy, and international relations. We are your hosts, Pavan Srinath and Hamsini Hariharan. Your personal data has never been more valuable and has never been at greater risk. Aadhaar has brought the privacy debate in India to a head, and the government is not the only one who can misuse your personal information today. The Supreme Court upheld the right to privacy in 2017, and the Justice Sri Krishna Committee has submitted its report and shared a draft law on data protection for India in July 2018. This happened even as we were recording this 2-episode special. These 2 episodes should give you a solid background to debates that you will see unfold over the coming few weeks and months on privacy and data protection in India. It should also give you a bit of a background on the Sri Krishna Committee's work. Our guest today is Rahul Mathan, one of the best minds working on the intersection of law and technology in India. Rahul is a partner at the law firm Trilegal. He is also a fellow at the Takshashila Institution and is the author of the book Privacy 3.0, now out in bookshelves. Last episode, Rahul walked us through the evolution of privacy as a norm and as a right across the world. In this episode, we focus on India and we focus on modern India. Rahul talks to us about how India has grappled with the right to privacy. He walks us through important debates that took place during the Constituent Assembly. We also discuss major legal disputes around privacy in India leading up to the Puttaswamy judgment last year. And we also discuss what the government and the parliament has been up to on privacy before this current year. We'll be back with Rahul after this short break.
Hi, I'm Vishal Gondal, an entrepreneur. I've had the chance to meet and understand how some of the super achievers have hacked their way to success, and they have done spectacular innovations. Now I take a closer look at these people's lives to find out what lies beneath the force, only on the Vishal Gondal Show. Episodes out fortnightly on Wednesdays on the IVM website, app, or your favorite podcasting platform.
Welcome back to the Pragati podcast, Rahul.
Thank you.
When we're talking about privacy in India, we start off with, did we ever have a culture of privacy in India? Why don't we read it into the laws? What happened to our Constitution Assembly? Where does all of this begin when you talk about privacy in the Indian context?
And I just want to add that most of our laws and the fundamental rights we've had were fairly far-reaching, and they were done with a lot of foresight, right? Indian society in 1947 and 1949 had deep social inequity. There was deep discrimination. There were huge social problems, and we were also very poor, right? So, but even then, and even though most of the population was illiterate, we said that we must have universal franchise. Why didn't that grand vision come through in privacy?
So, I mean, this is a very important question. Let me just answer Hamsini's question first. I think to say that we don't have a culture of privacy is actually not accurate. I think we think of privacy perhaps not in the extreme sense that Europe thinks about it, but it's not correct to say that we don't have a culture of privacy. We've had it for a long time. And in that context, to then look at our constitution as it stands today to see that there is no fundamental right to privacy written into the Constitution when, as you said, there are so many other far-reaching rights that have been written in, is pretty strange. When the Constitution was written, it was written at a time when the country is just fought off the British rule, where the colonial masters routinely violated our privacy. Certainly, this is something that we would have thought of, and we would have put something into the Constitution to prevent against. And even in the global context, we just this was shortly after World War II, where the world witnessed, and Europe in particular, witnessed the worst excesses of privacy violation, where people were identified by personal characteristics and put to death,
and who their grandfather or great grandmother was.
Exactly. Right? And so in many ways, if you look at Europe and the European approach to privacy, I would say that it was largely a reaction to what happened to them during World War II, and they wanted to ensure that doesn't happen. But in that whole context, India is writing this brand new constitution, a very long, voluminous constitution that took a long time to put together, and there is no fundamental right to privacy in it. It was very strange to me, and I think I started digging into it to try and find out whether there was any discussion at all. Was it a mistake? Did they think of all sorts of things? Just forget about privacy is possible? And then you look at the official transcript of the Constituent Assembly debates, and you find reference to a statement, just a single statement, which says that we considered including the fundamental right to privacy, and the subcommittee on fundamental rights decided that we shouldn't have it. So when I saw that, clearly it wasn't a mistake. Clearly someone had thought about it and excluded it. And then when you go into some more detail, you do a little more research, you start to find that the early drafts of the fundamental rights chapter actually did have reference to a right to privacy. Now, it's not the fundamental right to privacy written out as a fundamental right to privacy, but it's very similar to the US position, which is the right against search and seizure that is done otherwise than through due process and things like that.
So it was privacy around correspondence and
it's
that
privacy
kind
around
of
correspondence. It's privacy around your personal space. It's that kind of a privacy. It's certainly not privacy in the context of technology that we see today. But even that was not there. Ambedkar wanted it in, and there were at least two or three other.
Munshi was also
there. He also wanted it in, and so there's a strong body of people who were agitating for it. Why didn't it get into the final draft? And if you look at some of the detractors, one of the foremost detractors was B.N. Rao. And B.N. Rao was this constitutional expert. Jawaharlal Nehru actually appointed him as a constitutional expert. He was a judge of the High Court in West Bengal. He was a chief secretary of Jammu and Kashmir. He was an extremely respectable bureaucrat. And in order to try and find out what should go into this constitution, he actually went around the world stopping off at various countries, speaking to people there, jurists and experts there. And he goes to the US and he meets Justice Frankfurter. And he has a conversation with him. And through my research, I found out that Frankfurter at that time was having a deep disagreement with another justice of the court around this whole concept of due process. And Frankfurter believed that the fact that we need to follow this due process in order to prosecute someone is actually coming in the way of justice. Because whenever you have to go through all of those steps, people who they knew were guilty were getting off.
So things like getting a warrant before you do a wiretap.
Exactly. Any of those kinds of due process steps
makes law and order harder to enforce.
Makes it harder. And we all now think that yes, that's good because we also want to put a check on the government. But Frankfurter in his conversation with B.N. Rao says, look, if you are going to write your constitution, please keep this due process thing out of the way because you will regret it like I am regretting it now. I'm paraphrasing. No one was in the room. But I'm assuming it was that kind of a conversation. And B.N. Rao comes back and he removes due process, that the whole concept of due process from the constitution. And he puts up a very strong argument against the introduction of the concepts of privacy into the fundamental rights chapter. Now, if you think about it, almost all the people on the Constituent Assembly were people who leave the freedom fighters out, but a lot of them, B.N. Rao was one of them, were people who were responsible for the administration of British India. So these were people who actually were sitting on the other side. They were government. And they believed that if you give government power, government will exercise it responsibly. And so I think they felt that in a country as big as India, without the network and infrastructure that it needed, if we have these sorts of impediments, it would come in the way of the actual administration of justice. There's one line in it which says that if you allow this to happen, you will elevate every correspondence to the level of an official secret, which means that we will never be able to prosecute anyone. So if you think about it, the removal of the concept of privacy from the fundamental rights comes from a deep, and I guess a reasonable to the people who are articulating it, belief that the government would exercise its rights responsibly. And as we find that some of the biggest oppositions today to the concept of privacy is that the government is not exercising its right responsibly. But if you see why they did that, it's reasonable in that context. I guess it could be in the fervor of that time. It probably was reasonable. But that's why we, our final chapter on the fundamental rights doesn't have a fundamental right to privacy or anything like that.
So B.N. Rao's argument reminds me of a Harry Potter quote. So I'm not sure if you're familiar with this, but outside the gates of Nuremberg, which was Grindelwald's prison, it said "for the greater good," and that's typically an argument that's used a lot when we're talking about a state's responsibility, right? I mean, if it was something that was used with care, with responsibility, then for the greater good, this is something that you could leave out. It sounds similar to what we're talking about.
And the story also sounds similar to that of the right to property in India, right? Where it was in conflict with the social objective, the social revolution that the constitution wanted to bring about. And you could not have right to property and abolition of the zamindari system.
Correct.
And so they got rid of it. So in that sense, privacy also was a similar casualty, right? You wanted the state to correct the wrongs of society, to bring law and order and
You've got to be fair to them, right? Because I think they're looking at privacy in a lens which is very different from what we're looking at.
Absolutely.
There was none of the technological advances that are actually causing us all of this grief. And quite frankly, up until 2016, as I write in the book, even though the rest of the world was clamoring for a privacy law, there was no such hue and cry in India. I mean, I've been working on this privacy law since 2010, and I've had to convince people in government that there is a need for such a thing, and they're like, why do we need it? It's not required. And if you look at just the way in which we function as a society, we tend to be a lot more laissez-faire about privacy in and amongst ourselves than people in Europe are. I mean, the example, like I speak at conferences in Europe, and I give the example of when you get onto a train. In order to find your seat, your name, age, gender, and seat are typed out on a sheet of paper which is pasted to the side of the railway compartment and will be pasted for that whole night until it's ripped off by the wind.
Right.
And whenever I say this in Europe, there's a gasp in the audience, because in Europe you would never do something like this. And so this is the way we think about it.
And now we are doing online versions of the same thing, right?
Yeah.
I mean, CBSE 10 standard results, every student's name, maybe Aadhaar number, address, father's name, everything is out.
Yeah.
So, I mean, so more than maybe Indians not being concerned about privacy, the Indian way of governance and I mean, those norms did not necessarily respect privacy, right? The way we do our trains, the way we do board exam results and everything else.
Yeah, and I think that is even a little more modern. But if you put yourself back to 1947, when they're actually writing this, they're not thinking about privacy in the way we're thinking about it now. And so I can, in some sense, see why they're coming to it with that perspective. I think they were more concerned about ensuring that they could do justice, catch the criminals, not have the criminals come and say, look, you can't look into my correspondence because you're violating my privacy. I mean, they were like, we would never be able to maintain law and order in the country. The other interesting thing is at that time, when they finally decided to keep this clause out of the fundamental rights, they said that we should not elevate this to the status of a fundamental right, we should pass a law. And we haven't yet passed a law. So I think the trade-off was not that it's not important. It's that we shouldn't elevate it to the level of a fundamental right. But no one passed a law after that. And that's what got us to where we are right now.
And that's still the continuing challenge.
It's still a continuing challenge.
Okay, so therefore we didn't have a fundamental right to privacy in the Constituent Assembly, but surely there would have been many cases in Indian history where they would have had to consider privacy aspects, right? So I think you speak about the Kharak Singh case and the Govind versus Madhya Pradesh.
So the first case was MP Sharma, and in MP Sharma they mentioned privacy completely in passing.
Okay.
And all they say, but the important thing is MP Sharma is an 8-judge bench. I think in those days there weren't that many cases or something like that, but all these, MP Sharma was 8-judge.
When was MP Sharma?
MP Sharma was, I'm going to say 1954.
Okay.
It's very soon after the Constitution comes into force. So in MP Sharma they say in passing, they say that we don't have anything equivalent to the US Fourth Amendment in India, and so there is no such thing as a right to privacy. It's got nothing to do with the case also. It's just a observation.
But does that have a bearing, by the way? If a court, a judge makes an observation, people still cite it in later arguments?
So there's in judgments there's what you call the ratio, which is the main statement that the judgment is making. And you've got what we call obiter, which is the statements that are made in passing.
Okay.
Both, the ratio, of course, is binding on smaller benches or lower benches or lower courts. The obiter has got persuasive value. And the larger the bench and the more reasoned the obiter, the greater is the persuasive value of it. Now, this is an 8-judge bench. To be honest, very few people think about it after that. The next case is Kharak Singh. In Kharak Singh is a 6-judge bench. They don't actually get into the details of why the fundamental right to privacy isn't there in the Constitution, but they go into, and it's a bit of a mixed judgment. One part of the judgment says that the concept of privacy is a meaningful concept, and people shouldn't the state shouldn't violate it. Second half of it, they actually go strictly literalist, and they say, but there is no right to privacy in the fundamental rights, and so we can't do anything about it.
Okay.
Now, all of this is at a time when the Constitution was interpreted in a very literal way. So it was very clearly, if the words in the Constitution don't fit, then we're not going to read it in. Now, all of that changed by the time we got to Govind. And the judge who's looking at Govind had to deal with Kharak Singh, because Govind was decided by a 3-judge bench. And he recognizes that there is a problem in Kharak Singh in that there are two parts of the judgment where they seem to be saying two slightly different things. And I think he was quite torn. And I think we had, by that time, come to the stage of interpretation of the Constitution where we realize that the Constitution is a living document. And that the Constitution, we can't read it literally because things are changing in society, and we've got to interpret the Constitution in order to fit the new changes in society. So he then just comes to the conclusion by saying the founders of our nation, the people who wrote our Constitution, would never have intended for this state to become a police raj. And so we cannot allow for the police to violate people's privacy. And so he just read it in. Now it's strange because if you look at B.N. Rao's arguments, he actually was looking to make it not a police raj, but he was looking to support the police to allow them to actually do all of these things without allowing due process to come in the way. And in Govind, we get a judgment which says that the right to privacy needs to be read in a sense, because it could never have been their intention to create a police state.
Is it in Govind that they talk about reading it in relation with the freedom of movement in India? That if you have a cop who's looking at you all the time, do you really have freedom of movement?
And that's a beautiful passage in Govind. It essentially says, how can you have a freedom of movement where all your steps are being watched? In which case, there's nowhere in the country that you can move freely, because wherever you are, someone is watching you. So it's actually a very nice judgment. It's written very carefully and cleverly, but he just makes a bit of a jump at that one place because he can't reconcile the dichotomy that's there in Kharak Singh. And I think this is sort of the weak link in our privacy jurisprudence, because every case after that, and we've got 40 years worth of cases, and it's a huge range of issues, including the Nas Foundation on LGBTQ and 377, which is once again currently before the Supreme Court. All of these issues have been agitated in the context of the statement that he made in Govind. And the statement he made in Govind is made on slightly shaky foundations because MP Sharma and Kharak Singh, the two cases before that, were larger benches.
Right.
This is the reason why when we cut to the chase and come to Aadhar and the Puttaswamy case, as it's being argued, the AG can stand up and say, but we don't have a fundamental right to privacy in the country. And why can he say that? He can say that because, one, actually there is no fundamental right written into the Constitution. And two, the largest benches of the Supreme Court that have considered this issue have both said that there is no fundamental right to privacy. Every other case after that has followed from the decision in Govind, which is a 3-judge bench. And so, even though we have 40 years of jurisprudence saying that there is a fundamental right to privacy, it all is based on shaky foundations.
So whatever judgments we have on how you need due process before wiretapping in India, all of that is on shaky ground.
No. I'm just tracing the line of cases on the privacy side.
Fair enough.
To the extent that so wiretapping also comes under different provisions. We've actually got wiretapping laws. We've got rules under the telecom regulations.
Right.
Looking into the virus of that is a completely different thing, even though there have been many cases which go both sides on this. So wiretapping is one thing, then narco analysis of witnesses is another. And there's a whole set of cases on each of these things.
Right. So in a sense, then, can you say that how we don't, similar to privacy, we don't have very strong liability laws in India yet, right? I mean, we have some notion, and which is why you needed to create like a nuclear liability law to fix that problem in one ring-fenced area, because have no underlying strong liability laws. So in that sense, was privacy similar? That people had to plug various holes based on various forms of reasoning. There was no one underlying privacy law.
So, as a lawyer who is looking at all of this at the end of the 40 years, we, up until the AG stood up and said we don't have a fundamental right to privacy, we all just assumed we did.
Okay.
Because we had a series of cases which kept saying, look, there is this right to privacy. It's read into 14, 19, 21. And then when the AG stood up and said we don't, that's when we actually look at Kharak Singh and we look at MP Sharma and we realize that there is this problem. And it's not just us. The Supreme Court said, yes, this is an issue we've got to resolve. Everyone else, or even the petitioner said, look, let's sort this out because we can't have this coming in the way of the judgment, of the other judgment. So they immediately convene a 5-judge bench. The 5-judge bench says, look, if we are to overrule MP Sharma or even affirm it, there's no point us doing it because we don't have the authority. So they constitute a 9-judge bench. And that's the largest number of judges who ever sat down to think about these issues of privacy. And
this is Puttaswamy.
This is the 9-judge Puttaswamy right to privacy judgment, because the Puttaswamy case also is just fundamentally on Aadhar. And that's the case that is fairly recently been argued, and we're expecting the judgment in the next 30 to 30 to 40 days. So in that case, they sit down and they consider all of these cases. And they specifically overrule MP Sharma to the extent that it says that there is no fundamental right to privacy. They specifically overrule Kharak Singh to the extent that it says that there is no fundamental right to privacy. And they affirm Govind to say that the fact that they've articulated the right to privacy is correct. And so through that, they uphold the entire string of cases that followed, which had assumed that Govind was right. And now we've got a sort of a clear footing. And what the 9-judge Puttaswamy judgment says is that there is a fundamental right to privacy. The government cannot violate that fundamental right to privacy other than through a law. The law must be in response to a state need. And whatever the law says must be proportionate to achieve that need. So it's a threefold test. It needs a law. You can't just do it by executive action. Then that law must be in response to some clearly articulated need that the state must fulfill. And in fulfilling that need, the state can't be disproportionate in how it violates your privacy. It can only violate your privacy to the extent required to fulfill that need as prescribed by the law. So this is a very strong test that we now have to check just about everything.
And this changed the game, right? Because even now, the current hearings on Section 377 are in light of the right to privacy also being fully recognized.
Yeah, well, I mean, 377, he actually, I think all the judges, there are 6 opinions in the case, they all pretty much go into the earlier Supreme Court judgment and trash it. They say, look, I think the earlier judgment, so of course there's the great Delhi High Court judgment which decriminalized 377, right. And that was overturned by the Supreme Court. And the 9-judge bench said, you can't overturn this by saying that there is a minuscule minority that suffers from this. Even if, I'm paraphrasing, but they say even if one person suffers from this, and has a right violated, then that is certainly something that we can take up. And so they not only this, they go into all sorts of other things. They say that the state can't violate your privacy of what you eat in the privacy of your home. They can't violate your privacy on what clothes you wear. And they go through a whole set of examples like this, which I think in the years and decades to come, lawyers will be citing this case for a whole number of other instances of violation of privacy.
So in the coming years, we can expect many of our laws to get modified under the right to privacy, or because of the right to privacy. I haven't done that analysis, but certainly if we've got a law that prohibits someone eating something, right?
Clearly there is a direct precedent from the case. We could actually quote it. If we've got some sort of censorship law around what people should wear or not wear, certainly there can be a case. I don't know if we've got laws that prohibit that, but certainly there will be executive action. And we already have examples of all sorts of executive action like this. And I think the 9-judge bench has basically said that you can't do any of that.
You want to do the same thing, get a law in.
And then we will test the law.
Right. So the bar that is put has been excellent then, right? So even if there is a majority in the parliament, that is not sufficient to bring in a very draconian anti-privacy law in place. Exactly.
And one of the arguments is, why do we need a right to privacy? And I think it was Nariman who said it. He said the reason why we make it a right is because we don't want the majority government of the day to change the law. They will not be able to change the right.
Right.
So essentially, what the Constituent Assembly said, we should not elevate it to the level of a fundamental right. The 9-judge bench has said, I think we have to, because if we don't, the government of the day will change the law. And we have no control if it's just a law. So we have to actually lift it up and bring it to a right, so that whatever the government of the day does, they have to test it against the right.
Okay. So Rahul, let's look at the parallel story, right? So this is the legal history that's happened. What has been the legislative and executive history that's happened in parallel? So you were involved in efforts to come up with a privacy law in 2011 or so. Where did that sort of start from?
So, when the other project was announced, it was an identity project. And at that point in time, I was acutely aware of the fact that as you pick up personal data of people and as you use this identity mechanism to seed the various databases, because it was inevitable in my mind that once you have a good form of identity, every government database, every private database, everyone would actually look to try and incorporate that identity into their database, because this is a reliable identity. Up until now, we had no really reliable identity to the extent that this was, and once it becomes that, then people will use it. And then in the absence of having a privacy framework in the country, all sorts of violations could potentially take place. So as this project starts, I felt it was important that this was a good time to actually have a privacy legislation as well. At that time, we were one of very few countries in the world that didn't have a privacy law. That itself was strange to me because as an IT hub, I know that a lot of my clients who do work for US and European companies keep getting asked, what does your privacy law have to say? And our answer was, we don't have a privacy law.
Right.
It was quite strange. So I've been agitating for a privacy law for some time, but in the context of Aadhaar, I thought it was even more important that we had it. And so I had the opportunity to speak to Nandan and tell him about this, and sort of convinced him that there was a need for this. And to his credit, he actually put in a word with the Prime Minister in the Prime Minister's office and convened this whole this meeting where I presented an approach paper on privacy, essentially saying that if we were to have a privacy law, this is the approach that I would take, which would be you get best practices from around the world and incorporate those best practices into a law which would be a global standard law.
So this was a privacy law and not a data protection law?
It was a data protection law.
Okay.
Very much focused at personal information.
Okay.
This was not focused on, I think, in many of the other things that would have been covered within the ambit of what the 9-judge bench actually articulated. In many ways, everything we've discussed so far is really the state violating our privacy.
Right.
But it had got to the point where I was quite clear that corporations would also violate privacy. And a fundamental right operates against state action. It doesn't operate against private action.
Right.
I think we needed that as well. Of course, now what I say is we need a privacy law that addresses both state as well as private actions against privacy. And I hope that's what Justice Sri Krishna will come up with.
Okay. So you started working on this. Can you tell us a little bit about the administrative competition and challenges that were there? Because it makes for a great story. If I'm not mistaken, you worked with the DOPT,
Department of Personnel and Training, yeah.
Which also sounds like an odd department.
Not really, because the
this,
DOPT is responsible for RTI, the right to information.
Okay.
Now, if you think about it, the right to information is a private citizen's right to know public information that the government has. The other side of the spectrum is the private citizen's right to prevent the government from knowing, or not the government, but it's anyone, from knowing information which is not public, which is private and personal to the person. I mean, it's not a reason to put it with DOPT, but in my head, that seems to be one explanation for why
Which is fascinating, right? I mean, off the top of my mind, it would not make, I would not think of DOPT as a natural
And quite frankly,
problem.
within the government, they were not very happy with this because the Ministry of Information Technology at that time had come up with the Information Technology Act, and they felt that by rights it should be them that was drafting the law. So, I really don't know how and why DOPT got involved. This is an explanation that I think makes some sense.
Okay.
But I know that the first time, when I presented the approach paper, in the beginning, everyone said, yes, we absolutely have to have a privacy law. And then as the comments started coming in, you started realizing that every person at that meeting had their own agenda. And they were all coming up with their own versions of the banking regulator said, look, we don't really, we should have privacy as a concept, but it doesn't matter because as far as the banking regulation in that sector is concerned, we have our own provisions.
Right.
The telecom department has its own provisions. The Ministry of Information Technology actually said, look, we have the Information Technology Act. Within the Information Technology Act, we've got a specific provision which talks, that by that time 43A had been introduced into the Information Technology Act. And 43A is a very outsourcing focused clause.
Sorry, what is 43A for people who don't know?
So 43A is a provision which is the only thing that up until now we have, which takes the shape of a broad privacy regulation. 43A essentially speaks about personal sensitive information and the fact that you can't collect personal sensitive information without the consent and it's a small paragraph, but essentially that is where we derive our privacy regulations from right now.
And this was largely around Indian enterprise software companies having data of foreign companies, and
US
therefore
companies.
there need to be some protections around that.
Correct. It wasn't anything. It didn't say anything about how a company would collect information about people in India, or there was no detail at all. It was a simple provision. So I could see that there was all of this opposition. And then we went away to write our law because the committee secretary said, this sounds good, let's go ahead and come up with a draft law. And while we were doing it, I heard, I think, in the press that the Ministry of Information Technology had issued the privacy rules. So these are the rules under 43A.
Okay.
And the rules under the 43A, if you look at it, there are 8 rules, of which there are probably 4 effective rules because there's, as with all these rules, there's some fluff in the beginning and some fluff in the end, and there's definitions, and then there are 4 effective rules. And the 4 effective rules are all we have today.
Okay.
If we say we've got a privacy law, it is the rules under 43A that people have to abide by.
And this is entirely subject to executive action.
This was passed by an executive action.
Right. And it can be changed by any executive action.
It hasn't been. I mean, there have been some clarifications since, but it hasn't been.
Okay.
But also, when I looked at it, it looked very similar to the presentations I had made at the approach paper. Essentially, I had culled out certain things. Consent, you shouldn't transfer without consent. You should have some sort of adequacy if it goes outside the country. How long you need to keep it for. All of these sort of little buzzwords that any privacy law in the world has. So I was really puzzled as to how the Ministry of Information Technology could pass what was essentially a full-fledged law. Whereas I here am, breaking my head trying to convince Home Ministry and all these various people as to why we need to have a proper full-fledged law. And the process, the legislative process is, I discovered, much harder at the executive level, where all the various departments of government have their own 2 bits to add. They want an exception for this. They want why this shouldn't be there. Then I think the actual putting it before Parliament and getting it passed. I mean, I don't know because the draft that I created never went that far. But I know that this process itself was cumbersome. And then the Ministry of Information Technology had overnight literally passed the privacy rules that we're all subject to. So I looked into it in a little more detail. And 43A left 2 terms undefined. What is the definition of sensitive personal information? And what are the security practices and procedures that need to be followed by anyone who is collecting this information? So the privacy rules are actually called the Information Technology Act Definition of Sensitive Personal Information and Security Practices and Procedures rules.
Right.
Because they had no legislative competence to enact rules on anything other than these 2 things.
And those 2 things were present in the language of 43A.
Of 43A.
Right.
And also the rulemaking power under 87.2OB. So 87.2OB says you can make rules on these 2 things.
Right. Not on privacy as a whole.
Not at
None
all.
Of those things.
But when you look at the actual text of the privacy rules, it is on the full, the full gamut of privacy. So this is one of those examples where the government has sneaked a law in through the executive process, where in my mind it can only come in through a legislative process. But we have nothing else. No one has challenged the privacy rules to the best of my knowledge. I've challenged it to the extent that it's been struck down. And so every one of my clients who comes and says, what do we do as far as privacy in India? I have to say, look, there are the privacy rules and this is what they say and you have to follow them. The privacy rules are extremely incomplete. One of the most important things that a privacy legislation needs is what is the consequence of not following the rules. And there's no such thing.
Okay.
So I have various provisions saying that I have to get consent and I have to do all of these things. But if I don't, what happens? We have to go into the Information Technology Act, look at the residual punishment that is there for any violation of any provision of this, and tell our clients this is what it is, which is really not an effective way, quite frankly, to advise clients or even to base a strategy on. But that's what we have.
Okay.
And that is all that we have to protect us against modern technologies, to protect us against anything. Europe and the US have very sophisticated laws, very purpose-focused laws. We have the privacy rules, and I think it is a dangerous situation to be in. So we more than ever desperately need a privacy law now.
Okay. Rahul, can you also tell us a little bit about this National Data Controller Registry? I mean, in your book, you speak about it as an idea around the same time as you were drafting the rules.
We wanted to do something which was a little easier. Now, it's a little dated as a concept, but in 2012, 2012, I think when we put it up, one of the big problems was, once again, something similar to what I discussed and I say is an issue even now, is that you've given someone your consent to collect your data and use it for certain purposes, but you don't know what each person is using it for. And if you've given it to hundreds of people, you have no idea. And in order to find out what a particular person is using your data for, you have to go back to them, look at their privacy policy, try and figure out what they have disclosed. So what we thought we'd do is have some sort of a registry, an online registry that is searchable, where anyone who collects data has to put up limited information saying, look, I'm collecting data for this use. So I can...
And this type of data.
For this use. And then I as a data subject could go to that registry, search it and say, I want to know Airtel, for example. Airtel is using my data for what purpose?
Right.
And I get a full set of purposes. One single place where I can go and get this information from, as opposed to going company by company or department by department to try and find this information out. I mean, I don't think any country in the world has something like this. I don't even know if it is effective. And in the context of my more recent thinking on this, I think we probably have to come up with a completely different way of addressing this problem.
Okay. I found it very interesting that, while people would agree with you in government that privacy is a good thing, we should have a law, etc., it's only when you told them that even Pakistan has a privacy law and most countries in the world have privacy law, that the idea of a precedent existing in another country motivated certain people to act.
Look, I mean, I think the challenge that I found with government is that when in 2011, when you're speaking to them about privacy, you're essentially telling them that there are certain things that you cannot collect about people, or if you collect it, you've got to treat it carefully. Now, for about a decade, they have been punished by the Central Vigilance Committee and other avatars for not being completely transparent. The whole challenge with government for the last the decade before that was, the government money is going into pockets without a trace, and the government had built a whole machinery over that entire period to demonstrate transparency. One example was that if a government medical worker goes to a village to treat a person who is unwell, they would paint on the side of the house the name of the patient, the illness that they were suffering, and how they were treated. So that everyone knows that the government department has actually spent its money well.
Right.
To tell that person that this is a huge violation of that person's privacy is a little contrary to that person's way of thinking, because for all of this while he's been told that you have to be you have to be open and transparent about every paisa that you spent. And now you're telling him that no, you can't do all of this. So there's a, once again, there's a shift of mindset that was required. So sometimes I would just say, look, every country in the world has it, and even that was not good enough. And I'd say, even Pakistan has it, and that struck a chord.
Pakistan is a motivator for policy making.
Yeah. If only it actually did work, we may not be here right now.
Okay. So, but even after this, I find it interesting, the IT Act, and the rules being so all powerful that were passed, and even later, even the Aadhaar bill gets passed through as a money bill, right? Which raises certain concerns. But from the failed legislative efforts of 2011, I still think, that was useful because you set the stage. The idea got socialized within government, right? So I think, I strongly believe that whatever can come through now is because this idea has been rattling around in people's heads for at least a decade now. And I think, we like to believe that is important even at Takshashila, this idea of socializing ideas well before they actually become policy. So, but cut to now, what is the government thinking now? Tell us a little more about the Sri Krishna Committee, and then we'll get to sort of your proposed solution.
So, look, the Sri Krishna Committee has spent, I think, probably about a year now looking at the issue of privacy. And
who set them up?
It was set up by the government.
Okay.
I think I don't know the exact motivation, but at that time, the Aadhaar case was being heard. The Puttaswamy right to privacy judgment was being heard, and the government announced in open court that we are setting up a committee to go into this. And I think if you look at the judgment, all the judges actually refer to the fact that there is a Sri Krishna committee that's been constituted, and that they are going to come up with a full-fledged law. So I think, to some extent, the fact that a committee was appointed allowed the judges to say, okay, look, the government is doing something about it. So we're not going to get into the details of what should be in the law because there's an expert body that's looking into it. And I think, the first output that we got from the Sri Krishna committee was this white paper. A very exhaustive white paper that touched on a number of issues, probably more than I thought was necessary. But, more is good in this context. And, presented both sides of most issues, came down with some sort of recommendation that they felt as a preliminary recommendation, and invited comments. And I don't know how many comments they received. I believe it was a large number. And then they also did a roadshow where they went around major cities and discussed this with stakeholders. So it was a fairly extensive exercise, and we're expecting the report to come out anytime now. Maybe it's dropped while we're recording this.
Okay.
And we're hoping that the report will consolidate the research that was done, the inputs from stakeholders, and prepare or present some sort of a draft legislation. And that draft legislation, hopefully, will be something that the government can pick up and pass as a law.
As a data protection law or as a privacy law?
I think 98% of privacy today is data protection. Given that data can be just anything, videos, audios, anything is data today. There's no other way to define it. So in that sense, it becomes slightly semantic. But I think it will focus largely on the violation of privacy that can happen as a result of data.
So, and I've also followed this after our initial conversations a couple of years ago. And unlike most cases where it's usually death by committee, right? Problem hai, to okay, we'll make a committee, and then so you diffuse the problem and it goes away hopefully in 2 years. Or at least the government gets to go away. But here, the process has been quite rich so far, right? Lots of consultation, lots of public, public outreach. That we have not seen too much of. The only other thing I can think of is TRI and net neutrality, where we had some form of a national debate, which enough people...
TRI has been particularly good about doing consultations. I think maybe they pioneered the model.
Right.
And I think the committee has been fairly good at reaching out and seeking comments. there are a lot of people who argue that it could have been better.
Right.
I know I was at one of the consultations and they said you should be going to more places, you should be getting feedback from more people. But there's a trade-off you've got to do. I mean, you could be on the road for the whole year, and you could certainly get more feedback. But there's trade-offs that you've got to do. So the one thing is, I think the output that we have seen so far, the white paper, is actually a very good document. I think it covers all the issues. I don't think there's anything that they specifically missed. And I think they've been reasonably fair to pick up all sides and present all perspectives. The perspective of the government, the perspective of private corporations, the perspective of data subjects. And so they've done that fairly well. I think we'll need to see what comes out. But
Right.
if they follow the same process all the way through, I think we should have a reasonably good law.
Okay. And of course, the big question mark in this, I think, is the 2019 elections, because even if the report comes out now, there's a draft law ready in maybe a couple of months. We don't have too much legislative time between now and the elections.
I mean,
but it looks like a problem that no matter which government comes in, they will have to tackle sooner rather than later.
Except that, everything grinds to a bit of a standstill during elections.
Right.
And so it just gets delayed further. And for someone who's been working on this since 2010, it feels like, here but for the grace of God go I again. So, that's the...
And the policy window is open now, right? It's still
Till
at the
December.
back of people's mind
Yeah.
Yeah.
till December.
And I don't know what will happen in 2019. But if Aadhaar becomes an election issue, then who knows? Right?
So there's a lot of dynamics at play. I mean, I think if from a timing perspective, we've also got the other judgment that's going to come out.
Right.
And if the Sri Krishna committee report comes out before the other judgment, I see no reason why some specific reference can't be made in the other judgment itself to the Sri Krishna committee. And the fact that the government must enact the privacy law. I mean, I don't want to put words in the mouths of the judges, but it would be great, if they could actually look at the output of the committee and say, you put some sort of restriction on the government. Say you have to enact this law almost as a condition for upholding, which is what it should be. I mean, I think we absolutely must operate within a framework of reasonable privacy legislation if we are to do things like Aadhaar and I keep saying, even if Aadhaar is struck down, there will be some other technology that will come. It is inevitable. That is the march of technology.
Right.
So in that context, we've got to think about privacy. We can't, say, look, we've struck down privacy, struck down Aadhaar, and so let's forget about the privacy law. We absolutely have to have privacy, have to have a privacy law, because governments are violating privacy, big corporations are violating privacy. We just have to have rules of the game within which to work right now in this time that the world is in.
Yeah, I'm very happy to see that in parallel there's a conversation on electronic medical health records. Yes. And, who owns the data? What can you do? Do you have portability? There are a whole host of issues specific to that sector. So I'm happy to see that in the context of a privacy law being enshrined, every
sector will. And, medical health, to my mind, is one area where India can really benefit. I mean, if we have an EMR, EHR law that comes out, that hopefully creates a taxonomy for EMRs and EHRs. That is something that I don't think any other country in the world has. Every country has its own proprietary systems that don't talk to each other. But if we can actually create some sort of taxonomy that will work across the ecosystem, it's just going to be so much easier for people. They'll have much better managed health records longitudinally over a period of time. But the moment you do something like that and you create this taxonomy that is interoperable, huge privacy issues come up.
Can you be denied insurance based on your genetic condition?
Can you be discriminated against? There's just so many other things that will come up.
And I mean, I find this interesting because one of our biggest challenges in health is that our public health is terrible, right? I mean, even when we think about government's role, we think about government-provided health care, which is largely private goods and services. But we don't talk enough about sanitation, drainage, lack of mosquitoes and so on, which are causing a lot of these problems to begin with, right? And even there, data plays a big role.
Huge.
Right now, we have no idea when dengue is breaking out in
But
Bangalore.
if we had if we had a data-driven approach to dengue as an example,
right,
we could have so much more effective treatment of
absolutely
the core issue.
You know that there's a breakout near Alsur Lake. You go fumigate, you go target, you
Correct.
go do something there. You know that it's spreading.
And
at
the
a
only way to
school.
know that is if you actually know where people live.
Right.
So if everyone is coming to Bowring Hospital from Alsur, don't go and fumigate Bowring Hospital. Right? Currently that's all the data we've got.
Right.
But if we can actually get the data of where people are coming from, create heat maps, we can use that and that's how Singapore dealt with the avian flu. They actually got heat maps of where people lived, focused their efforts on those areas, and eradicated it at source, and that's
exactly how the first efforts against cholera happened even in London.
Exactly.
Right? People mapped the thing, and we need data. So yeah, it's a good note. So let's sort of end on your model that you propose, that even our colleagues Mansa and Ajay have worked with you on. Tell us a little about it, and then we can get our listeners to read more.
The idea behind that stems from the fact that I think that we're at an age where there's a tremendous data asymmetry between us, the data subjects, and the people who collect our data, either the government or corporations. So we give up our data in many more ways than we actually know. And all of this data is being hoovered up by various entities that are collecting and controlling this data, and they're manipulating this data in many different ways. And we have no ability, even though we have consented to this data being collected because we've signed up their terms and conditions or whatever along the way, we really have no control over what they do with the data. We don't understand why they've collected it, what they're using it for, or what the consequences can be to me. So, and very often corporations actually point to the T's and C's to say that you've signed up to these T's and C's, and therefore you cannot hold me liable for what happens to you.
Right. In the last episode, you talked to us about how consent becomes the excuse for companies to get away with it.
Exactly. And I was trying to find some way to address that. So the model that we have come up with is what we call an accountability framework. It doesn't do away with consent completely, because consent is required to sign up to a service, right? So you can't just be automatically signed on to a service. But it forces corporations to be a lot more mindful of what they do with your data. And it hinges on imposing fairly stringent penalties on them. So I've proposed 4% of global turnover as a penalty, which is not unusual. These are competition level fines. It's what the GDPR has in Europe. This is not an unusual number, but it is hopefully a significant enough number to be enough of a deterrent to corporations to prevent them from actually just running roughshod over data. The idea is that if you cause any harm, and the harm could be financial, it could be reputational, and I also suggest a harm which is sort of the harm in terms of the constraint of choice. And this is very much the filter bubble problem that we have.
No, and that has large bearing in economics, right? The idea of consumer choice, consumer welfare.
Exactly.
It's well enshrined.
Exactly. But, to look at it in the context of the consequence.
Right.
And then say that if that consequence occurs, then you will be liable for the harms that you have caused. So that's essentially the model. But, that of course is, it's buttressed by many things. One is, I suggest a granular opt-out for everyone who collects data. So very often, you have the ability to opt out. I mean, most people have the ability to opt out once they've given consent, but that becomes a take it or leave it kind of an opt out.
Right.
And that's not necessary. What we should do
like
is,
right now I sign on to Facebook, I have to agree to all their conditions.
Well, Facebook is actually a not a good example, because Facebook already has granular opt out.
Right.
If you go deep into the settings, you can go in and switch certain things on and switch certain things off.
Right.
So there are certain essentials. Like, for example, Google Maps needs your location data to give you turn-by-turn directions. If they don't know where you are, they will not be able to navigate you through the map. So you can't say, I don't want you to have location data, because then Google Maps will turn around and say, I will not be able to take you to where you are. You can have a really nice map and you can
Or
figure
the
out how to
same
go.
thing with some place like Uber, right? Unless you give them access to
Exactly.
your location,
They will not be able to send the car to where you are. So,
Yeah.
right. So those are certain givens. But then for Uber, do they need my location information 5 minutes before I choose to order an Uber? There are some ride-hailing apps which say, look, if we know where you are, we will be able to better optimize the car to be close to you. Now, how do they do that? Essentially, they know that every day at 6 p.m. you normally call an Uber. And so they will say, okay, so now it's getting to 6 p.m. Where is he right now? Can I now then arrange the cars so that they're there so that he can get it in front? It's great service.
And then can I give a little nudge notification saying book your Uber now?
Yeah, exactly. So I think you can see where as you start slicing this, it starts violating privacy. There's a point in time where this is really great because it's a good service and it's very intuitive. But after a point in time, it starts violating privacy. So essentially, I want the ability to granularly opt out of this. I want the ability to say, look, I want to use your service, but I want to use all of these things. I want to switch these things off. So that's the granular opt-out. And then the second leg of this is this concept of learned intermediaries that I suggest. A learned intermediary is just a title for someone who is well versed with technology enough to be able to look at the app or look at the service and say, look, this app is doing such and such, which has this consequence on privacy. The reason I think we need something like that is because the vast majority of us, and even I consider myself reasonably up to speed with technology, I would do with some translation. It would really help if some expert can tell me, look, this app is dangerous to you because it keeps your microphone on when it's only a calendar app. Now, why would a calendar app want your microphone? Of course, the answer is maybe you can dictate your meetings to it. But, do you really need it?
Right.
Will you switch it off? Because it keeps it on throughout the day. Now, this sort of information non-technical people don't have.
Right.
And so I want to find ways in which we can shift this data asymmetry to bring more into the control of the data user. And eventually, I think this learned intermediary concept will grade apps by their data policies. So you can have apps that are grade AAA on privacy policies. Hopefully, in time, people will self-select towards those apps that have high rankings as far as data is concerned. And then we'll be talking about a completely different world.
So you're saying, like chartered accountant, will have a chartered technologist who will
like that.
come and tell you.
But I think that the economic dynamics of that is really important. We've got to ensure that this learned intermediary is working on behalf of the data subject.
Right.
Auditors typically are paid by the company. That's a model that could still work, but we've got to find some way in which the auditor is incentivized to constantly keep the interests of the subject in mind, and not the company. And I think those are the kinds of things that we got to get into in a little more detail as we create this model. So a learned intermediary is just a sort of a translation layer for the plain old Luddites like us who really don't understand the deep nuances of technology.
Right.
We just want some way to give us a sort of a heads up. And we've got this concept of white hackers today, right? And for people who know, they actually can already go onto message boards and figure out, is this a good app? Is this not a good app?
Right.
But the vast majority of us don't know and don't have that. And I'm trying to find a way in which we can create a structural mechanism to address that data asymmetry.
Okay. But so Rahul, this is about largely data and its collection, right? What about algorithms? Because the challenge now is not just what data is being collected, but then how decisions are being made. So if say there is an app which collects a lot of my information, which I consent to, and it's okay for them to take it, it makes sense to say, give me a loan. How do I know? What if that decision making is a black box?
So that also is falls within the accountability framework, right? So the one part of it is the collection of the data. The second is the use of the data. And you will be accountable for the use that causes harm.
Okay.
And that's the entire construct.
Right.
And so if you have a learned intermediary, the learned intermediary will also be evaluating the output-based consequences of what the data controller is doing.
Okay.
So, if we find that a algorithm is tending to favor one gender over the other,
Right.
this is not something that you and I will really figure out. But if you've got a team of auditors, learned intermediaries, who are focused at picking these sorts of things up, there's a good chance that they will be able to highlight it, because that's really what they're doing. Now, it's actually very difficult in algorithms to identify this upfront, because some of these algorithms are black box algorithms, and
Right.
the exact logic that they use to get a result is opaque to us. Those we'll have to see on the margin. So we'll have to check the output
Right.
on the margin, and as soon as possible identify a bias that is there in the algorithm. And another part of the model really is that we've got to focus on remediation as opposed to punishment. The nature of algorithms today is such that there is going to be a lot of hit and miss. We have the option of saying only use completely safe algorithms, right? So ensure that the algorithm does not bias one category over another. But every algorithm that we put out is probably going to have some bias. I mean, a lot of the ways in which algorithms do their magic today is by studying historical data.
Right.
And historical data has all our historical biases
Right.
as human beings already in it. Sometimes we don't even see what those biases are, but the machine will pick that up and will spit it out as if it's an algorithmic decision. Now, we need to be able to detect that. And if that does happen, actually the corporation is not responsible, or it should not be liable. It is responsible, but it will not be liable if once it's been pointed out to them that there is this bias, that they quickly take remedial steps to fix it.
Right.
And we've got to do that, because otherwise we will stifle innovation. And I know there's a big debate around whether we should allow innovation at the cost of privacy or not. And I don't think these are simple. There are simple answers to these questions. I think we certainly have to find a way in which we can address it. I think a remediation regime is probably the most appropriate. If after numerous requests for remediation they still ignore it, then I think certainly we can punish them, and we can punish them with that 4% of global turnover that I had suggested earlier.
Okay. So clearly, being able to do this right requires high state capacity, right? I mean, the kind of intervention that you're talking about requires a lot of sophistication in how the government approaches this. So it'll be good to see, along with any law, how serious the government is about building an institution. We probably need another thing like TRAI, right? Which
we'll need a data
regulator
commissioner. We need some data framework.
Right.
You're absolutely right. This look, I don't mean to necessarily throw people at it. I don't think that's really the solution. I don't also want to. I hope that the government does not make it too cumbersome and complicated.
Right.
I think Europe has moved in the direction of an extremely cumbersome and complicated law, and I think that by doing that they will certainly ensure privacy, but the impact on innovation is going to be quite significant.
Right.
I think we've got to find a balance. But I agree with you. I think it is going to call for a high state capacity. I question whether we currently have that level of state capacity, but it is certainly something that we
need to develop.
We need to develop. I mean, we're developing state capacity in the implementation of technology.
Right.
We've equally got to develop state capacity in the protection against the harmful consequences of technology. And I think we need to invest in that.
Okay, thank you, Rahul, for that fascinating insight into the number of things that we've covered in this last 2 podcasts. Thank you so much for coming.
My pleasure. Thank you for having me.
Yeah. Hope to have you back here a little sooner than this particular time. But thank you so much.
Glad to. Thanks.
Thank you for listening till the end. Don't forget to check out Rahul Mathan's new book, Privacy 3.0. And don't miss the first episode with Rahul, where we talked about privacy and its history around the world. Send us your questions and comments to podcast@thinkpragati.com. You can subscribe to the Pragati podcast on the IVM podcast app or wherever you get your podcasts from. We are there everywhere.
Shunyavan billion-dollar acquisition. Another copycat startup got formed.
No, the tech world in India is surely moving double the speed of this voiceover.
Tune in to Shunya One every Tuesday to catch us talking to the smartest people we know on the IVM Podcast website, app, or wherever you get your podcasts from.
Yeah. It's IVM here, let's go. We the IVM kids on the block over here. Just to talk, taking a break from producing all day. Coming on this podcast cause we got stuff to say. IVM Daily is the name of the show. Monday to Friday, we ready to go. Talking about stuff in our head. We might even talk about our favorite bread. Signing out, it's IVM here, the podcast network that's in your ear.
Catch IVM Daily, Monday to Friday on the IVM Podcast app or wherever you get your podcasts.